Okay, let's dive right into this. Welcome, everyone. Go ahead and take your seats. Today, we are going to embark on a really intensive, fast paced crash course exploring the totally fascinating world of civil wrongs. We're going to unpack the invisible rules that govern our everyday interactions, everything from a simple slip and fall all the way to complex modern property disputes. By the end of this explainer, I promise you'll look at every accident, every careless action, and for sure, every noisy neighbor through an entirely new legal lens. Here is our official syllabus for today. We'll start with a welcome to tort law, move into unpacking the negligence behemoth, cover trespass, nuisance, and land, look at defenses to fight a claim, and finish up with remedies for making it right. Section 1. Welcome to tort law, defining the wrong. Before we look at any specific rules, we have to ask a really foundational question. What exactly is a tort, and why on earth does it even exist in our legal system? Well, to answer that, we look to Percy H. Winfield's classic definition. Now, fun fact, the word tort itself actually comes from the Latin tortus, meaning twisted or crooked, which eventually just became the French word for wrong. But legally speaking, torts are civil, non-criminal wrongs. They happen when someone breaches a general duty that the law has decided we all owe to one another. The state doesn't necessarily punish the wrongdoer directly, like they would, say, a bank robber. Instead, it provides the machinery, the courts, the judges, the bailiffs, so that the injured person can take the initiative and seek financial compensation. The law calls this unliquidated damages, which is basically a fancy way of saying the exact amount isn't pre-agreed upon, but is decided by the court based on the actual harm you suffered. Let's put on our Socratic hats for a second. How does this differ from the rest of the law? Well, in contract law, your duties are based on an agreement you willingly made, right? The goal there is to put you in the position you'd be in if the contract was actually fulfilled. In criminal law, the wrong is against the state itself, and the primary goal is punishment. But tort law? The duty is fixed by the law itself, not a contract, and the aim is literally to rewind time. The goal is to put the victim back in the exact situation they were in before the terrible event happened. Keep in mind, these areas can totally overlap. For example, dangerous driving can be a crime prosecuted by the state and simultaneously a tort where the injured pedestrian sues for compensation. So, that's the high-level theory. But what happens in the real world when someone simply isn't paying attention and that sheer carelessness causes harm to someone else? Section 2. Unpacking the negligence behemoth, the core framework. Of all the different types of civil wrongs, the tort of negligence is the absolute giant of modern civil litigation. It's the framework used for everything from medical malpractice to everyday car accidents. But listen, you cannot simply walk into a courtroom and say, hey, they were careless and I got hurt, pay me. No way. The law requires a strict 4-step checklist. First, you must prove the defendant owed you a duty of care. Second, that they actually breached that duty. Third, factual causation, meaning their specific breach actually caused your injury. And fourth, remoteness, that the harm you suffered was legally recognized and a reasonably foreseeable consequence. Let me warn you right now, as a claimant, if you fail to prove even a single one of these 4 elements, your entire claim collapses like a house of cards. So how do we judge step 2, the breach of duty? Honestly, the law does not care about a defendant's subjective intentions. You can't just stand there and say, but I was trying my absolute best. Instead, the courts use a strict objective standard, the reasonable person. This is an imaginary, average, reasonably competent individual. The court simply asks, would the reasonable person have been more careful than you were in this exact situation? If the answer is yes, you breached your duty, plain and simple. But here is where it gets incredibly complex. Negligence is a highly policy-sensitive tort. The courts are constantly walking this massive tightrope. They want to protect individuals and compensate them for injuries, absolutely, but they absolutely must avoid opening the floodgates to limitless lawsuits. Judges have to ensure that finding someone liable won't expose them, or society at large for that matter, to liability in an indeterminate amount for an indeterminate time to an indeterminate class of people. The law has to perfectly balance individual protection with social utility. Okay, so we've talked a lot about accidents and personal injury, but what happens when the conflict isn't about a dropped brick or a car crash, but rather the very spaces we live in? How does the law handle us living, as they say, cheek by jowl? Section 3. Trespass, nuisance, and land. Proximity and conflict. As populations grow and urbanize, the way we use and share property has become a massive battleground for tort law. Let's clearly delineate the crucial differences between these land torts. First up, trespass. This is a direct, immediate physical interference with someone's land, like simply walking across their lawn without permission. You don't even need to prove it caused damage to sue. Private nuisance, however, is indirect and requires some continuity. It's about an unreasonable interference with your quiet enjoyment of your land. Think loud, continuous noises or really foul smells. And then there's a highly specific legal doctrine known as the rule in Rylands v. Fletcher. This deals with strict liability if you bring something dangerous on your land, make a non-natural use of the property, and that dangerous thing escapes and causes havoc. And this brilliantly illustrates how these ancient property concepts are being tested today. Recent research on housing law, like what's covered in the Journal of Social Welfare and Family Law, focuses heavily on urban housing intensification. We are seeing a massive shift in how humanity lives, and the legal frameworks of the past are seriously straining under the pressure of the present. Densification, shrinking homes, and modern rent regulations are creating brand new battlegrounds for private nuisance. I mean, think about it. When people are packed into smaller, shared spaces, the potential for conflict skyrockets. We're seeing rising tensions over squalor and antisocial behavior. Interestingly, we're also seeing the state outsource the governance of this behavior directly to private landlords through licensing schemes and civil penalties. In this highly intensified urban environment, the line between an everyday annoyance and a legally actionable nuisance is constantly shifting. Now imagine you are the one being sued for a tort, whether it's for a nuisance or negligence. What if you aren't entirely to blame? What if the victim was also careless? Section 4. Defenses. Fighting the claim. We're shifting from the claimant's perspective over to the defendant's table to explore how you fight back against a tort claim. A defendant isn't just helpless, they have legal shields. If a claimant consented to a known risk, or if they were engaged in an illegal act when injured, the defense can totally raise those points. Sometimes it's just an inevitable accident that no amount of reasonable care could have stopped. But the most practical and common tool in the entire arsenal is contributory negligence. The defendant basically argues, yes, I was at fault, but so were you. If proven, the court will actually reduce the damages awarded to the claimant by the exact percentage they were to blame for their own injury. Which leads us to an overarching philosophical question that defines the end goal of every single civil trial. When is it actually fair to make someone who harms another person pay them compensation? Section 5. Remedies. Making it right. Winning a case on paper, proving all the elements, and defeating the defenses means absolutely nothing if the court cannot enforce a solution. So, how does the law actually make it right? Now, what's really interesting about this is how tort damages uniquely aim to rewind time. Unlike contract damages, which look forward to what was promised, the standard in tort is compensatory damages, paying money to restore the victim to their exact pre-incident state, whether that's covering medical bills or lost property. But courts have other tools too. If a defendant was truly malicious, aggravated damages can be awarded for injury to feelings. And in very rare extreme cases, the court might award exemplary damages, which step outside the normal bounds of tort and actually seek to strictly punish the defendant for calculated misconduct. But remember, while money is the usual remedy, it is not the only one. Sometimes a check just doesn't fix the problem. If your neighbor is currently digging a giant hole that threatens to collapse your house, you don't want money later. You want them to stop right now. That is where equitable remedies come in. The court can issue an injunction, a super powerful legal order demanding a party stop an ongoing harm. They can issue declarations to formalized rights or order specific restitution to physically return property to its rightful possessor. We've covered the entire syllabus today, from the fundamental definition of a wrong to the absolute behemoth of negligence, property clashes, defenses, and remedies. But I want to leave you with a final thought to ponder as class is dismissed. Looking at our modern, cheek-by-jowl society, with its complex property issues and risks literally everywhere, does this intricate system of duties, breaches, and damages actually achieve justice? Does it successfully balance our need for individual protection with the utility and freedom of society as a whole? Think about that the next time you walk out your front door. Thanks for joining this explainer, and keep questioning the law around you.